the Criminal Procedure Code. It's an old enactment with some amendments subsequently. The Indian Evidence Act. All these enactments are of the 1860, 1872, etc. They are very old enactments. Now these enactments have stood the test of time. In today's day, there were some aspects which were bothersome. I think what was bothering was we were changing our penology. Now, over the years, concept of plea bargaining came from the US into India. Concept of victimology came from the US. So slowly there was this feeling also that the state is not always being competent in protecting the right of the complainant or the family of the complainant who have a grievance. Slowly over the last 20 years or so, this concept has reduced, partly with the fact that there is an overburdening of courts. You want plea bargaining to come in. You want that if you bargain for a lesser plea, India is still not mentally got attuned to plea bargaining. We have this section, but we don't have it. There's been a huge history of up-down. We had UAPA, then we had TADA, then we again have the UAPA 1967. The reason was successive governments have found that law defining terrorist activities have been misused by a government in power to quell dissensions against themselves. Now, what is terrorism? The definition of terrorism is anything that will go against the unity or integrity or sovereignty of India. Any crimes which are intended to attack the sovereignty of India, integrity of India, the unity of India, will be termed as terrorist crimes. Now, I don't know why this is being sought to be introduced again, because UAPA 1967 is already in existence. It has done up, down, been abolished, been brought back, amended, so on, but ultimately it's in existence. And this is creating a parallel regime of UAPA. What is the purpose? What is the intention? Only time will tell. UAPA is an adequate provision. In fact, it has adequate protection even in terms of bail. All these special laws, whether you say Scheduled Caste, Scheduled Tribes Act, UAPA, NDPS, all of them are very stringent with regard to bails. And there is almost a principle of no bail. So, I have not understood what was the necessity. One can be, let's have one single act. But in many countries in the world, they have special acts for terrorist crime. I think in one of the countries, either the UK or US, they have a Patriot Act. So basically, every time a nation tries to abolish law pertaining to terrorist crime, they realize they don't have enough teeth to handle it. India is in a very sensitive position. So I don't think you can get rid of all laws with regard to terrorist crime. You do need something in place. You need something strong in place. But you need to make sure that it is hedged in so well that it cannot be misused at the hands of unscrupulous people, which is there for every law. But the greater the punishment, the more careful you have to be of its misuse. I think it's as stringent. I am just saying that most countries, even when they've abolished the acts relating to terrorist crime, have felt the need of reintroducing them. So this is basically saying that if the act does not result in death, then the punishment is different. If the act results in death of people, say like a Kasab case, then obviously the punishment has to be stringent. It has to be the severest of severe punishment. And that's why what we have here, that it goes up to life imprisonment and fine. So it is stringent, but even the previous law was stringent. So this is really a semantic change. It's not a very big change. So while I'm talking of offenses with regard to women, there is no harm, but it's only a semantic or a decorative change by bringing them under one overall provision. See, earlier there was no separate provision for mob lynching. Now it's become a standalone offense. It's not that you didn't have penal laws which covered it. Killing people, murdering people, causing is mob lynching. So that was part and parcel of an offense. If you remember that one woman who committed sati, and then there were all the persons who stood on and watched and nobody did anything, everybody was accused. So clearly, simple non-participation is normally not an offense. I am a passerby. I find 10 people being noxious to one person. I may not start taking on a fight with those 10 people. So I can't become an accused. But if I am participative by being present there and saying, जिसको कहते हैं उकसाया, या participative, then that's part of the offense. So do those who stand and serve also be guilty or not? To my mind, the attempt is to ensure that people do not become part of a mob mentality and add their might to something wrong that is going on. So the earlier provision was 304A and it was punishable with 2 years. Now if you remember the BMW case or other cases, an interpretation kept happening that these were not just simple hit and run or rash and negligent driving, they were worse. So in this, it was bailable. So now it's been made punishable with up to 10 years and it is non-bailable. So I only believe that there will be genuine cases which are just rash and negligent acts, but the punishment of only up to 2 years was considered less. That I felt should have been increased. Should it have been 10 years? Should it be 3 years? Should it be 5 years? Who are we to say? This parliamentary committee is expert committees have to sit, they have to compare the law with other nations. All changes in law, if Macaulay took years and years writing the code, I feel we've done some work on it. A lot of genuine work went into these enactments. I feel some more time was needed. These are earth-shaking laws. So such earth-shaking laws need experts to sit. If somebody sat locked up in his room morning to night for days and months on end, have we done that exercise? That's the only question. So one thing I find very welcome, that is that whenever you do a search and seizure, there should be a videography. Now if the police actually do the videography, half our problems will be over. Because what the police does is, when they want, there are 3 people before them. One may be guilty, or all 3 may be guilty. 2 may have influence, they may go scot-free. Their names may not be added in the FIR or in the charge sheet. One who is innocent and financially weak may be the only one who will get the stick. So then there is sometimes to police to pad their case, and this is very common by many courts, they observe this, they show a recovery from that person. कि वो मुझे एक खेत में ले गया, वहाँ उसने मुझे छुरी दिखाई या डंडा दिखाया जिससे उसने उसके सिर पे मारा था. And they've already, the forensic has already done, the medical is already done, it shows के डंडे के marks हैं सिर पे. So then the 2 added up, and because his disclosure results in a recovery, that man, it is, his disclosure statement is believed. That's what the penal law is. We already have a police, and this is the one weakness of the Indian system. Our police is not an educated, trained police. I'm very happy that there is an attempt to bring in some transparency. I think there is an attempt. Let's see how it works. We have to have enough labs. We have enough forensic studios. We have to make sure that the scene of the crime, you pick up all fingerprints, you pick up everything first day, first hour, first 2 hours, so that nothing is destroyed. And you have to, because today is a day of much more genuine evidence. How many cases have been caught out even on conversations, WhatsApp, videos, audios, calls, evidence picked up from CCTVs in so many cases. We have to have it. How was Nirbhay's conviction happen? They did it scientifically. We can't do it in one case alone. I feel we need to work more on this, but it's already an act done. Now it will be for the courts to interpret. I hope we interpret it where we don't forget human rights, and we remember that every individual has a right to be considered to be innocent unless proved guilty.